The, did you prepare that exhibit?
I did not.
Do you know who did?
The Utah County Attorney's Office.
All right. And I'm referring specifically to what's been marked State's Exhibit 12.4. What is depicted in that video?
That video is, again, a compilation of videos from the overall footage that was obtained from Utah Valley University for September 11th and September 12th.
And how does it compare to what's been marked as State's Exhibit 12.1?
It appears to be the same footage. However, on this particular version, there were no circles or blurs that had been made to the video.
How about zooming in and zooming out?
No, there was no zooming or zooming out.
Does it appear to be identical to the raw footage that you've seen that portrays this particular part of the UVU surveillance video?
It does, yes.
Judge, the state would move to admit what's been marked State's Exhibit 12.4.
Your Honor, we just object to the publication of this for all the reasons we argued yesterday. We think this video is going to play a big role in the trial, and to allow the public to see it now would seriously impact our ability to get a fair trial, and we're asking the court not to publish it.
Thank you. And Mr. Surgeon, and fair trial or interests favoring closure. And the court recognizes the importance of the constitutional rights of Mr. Robinson being upheld and protected. At the same time, the court also recognizes the importance of transparency and a proper balance to ensure that the constitutional rights of all parties are upheld. As it relates to this exhibit, I believe it's 12.4.
12.4, yes.
Based off the representation of what is in that, the court differentiates this exhibit from the exhibits from yesterday, namely Exhibit 7, Exhibit 8, and Exhibit 9, as those are different in nature, and those go to issues relating to Utah Constitution, Article 1, Section 28, as it relates to the Declaration of the Rights of Crime Victims. And the court also recognizes Utah Rule of Evidence 1102, as that is the foundation that's being laid for the admission of this exhibit. Having taken in consideration all factors, the court rules that Exhibit 12.4 is admitted into evidence and shall be played in the courtroom and may be broadcast by the media. And we can proceed.
Thank you, Judge. Just see happen.
The individual actually kind of rolls over the railing onto the roof of the Losi building.
All right. Go ahead, sir.
And again, in the top left corner, the individual is now seen running across the rooftop of the Losi building to what would be the southwest corner of the building, crouching down and then crawling to the corner of the building.
And this is at what time?
Around 12:23. I think the timestamp on the video is 12:22.
On the 10th.
On September 10th, yes, 2025.
So we're clear, this is the roof of the Losi building.
Correct.
Can you still see that individual?
Yes, you can, laying prone.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23 and 28. The individual then stands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. They move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
Do you see Mr. Robinson now?
I do, yes. He's just arriving at the corner of the building, almost the top center of the image.
What are we seeing now?
And Mr. Robinson lowering and jumping off of the roof of the Losi building onto the grass area, and then moving away towards Campus Drive. And he appears to be carrying some kind of an object in his hand at this time, something that had been secured by an officer.
And that building was the Losi building.
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my time there on September 10th, yes.
Which building was that, sir?
I don't recall.
Was that considered a scene that was worth preserving?
It was not. My recollection is that that was accounted for as an ejected cartridge from an officer who had cycled his rifle.
Okay, I thought you said it was an unfired bullet, and now you're saying it was a
That's correct.
cartridge?
When a weapon is cleared, an officer would make his rifle ready, which would chamber around.
Oh, I got you.
My understanding was that that's how that was accounted for.
So an officer claimed that bullet belonged to him or her?
That's my recollection, is that was how it was accounted for.
And when was that accounted for?
I don't know specifically.
Do you remember what type of bullet that was?
I don't.
Was it a 30-06? Do you remember?
I don't.
Okay. Do you know where that bullet is now?
I don't.
Okay. Do you recall an individual named Noah Gonzalez being interviewed?
I don't recall that name specifically.
Let me see if it refreshes your memory that he was an off-duty, I think maybe trooper that was on the scene that day and that was involved in recovering the holster. Does that refresh your memory?
I know that a trooper was interviewed having been on scene. I don't recall if it was Gonzalez. I don't recall the name, but I do know there was a trooper that was interviewed, yes.
Okay. And just a moment, Your Honor. And do you recall the trooper that was interviewed saying that there was actually a gun found in that holster?
I do not.
You do not?
No.
Okay. Can we pull up? Exhibit Hole 13 and just show it only to the witness for right now? All right, can we go to page 2 of that report? Do you recognize this report? Have you reviewed it as part of your investigation duties?
I do recognize the report now, yes.
Okay, and this is a report prepared by actually Mr. Davis, who's going to testify later in this matter. Is that right?
Correct.
Okay, and on page 2, this is the interview of Noah Gonzalez. Is that right?
That's what it stated on page 1, yes.
And he's an off-duty trooper who happened to be there that day?
Correct.
And do you see on the second paragraph, does that refresh your memory about whether Trooper Gonzalez believed there was a gun found in a holster in that area of the amphitheater?
Trooper Gonzalez included in his report that there was a gun, yes.
Okay. And that's the place where, if you could go to page 2, please. Do you see down at the bottom where you summarize Sergeant Bricker's report listing the timeline?
Yes.
Okay, and so it was actually Sergeant Bricker that prepared the timeline, is that right?
He prepared a timeline.
And you incorporated that into your report?
No, I created a timeline.
You created your own timeline?
Yes.
Separate from the one that's in this report?
Yes, using using information obtained in the investigation.
And when did you create that timeline?
Over the course of the investigation, over a long period of time, after a lot of reviewing video and investigative time.
So, as of September 14th, Tyler Robinson had already turned himself in to the authorities. Is that right?
Yes, I believe he turned himself in on September 11th.
So, prior to the time that Tyler Robinson turned himself in, had you all prepared a timeline?
A documented written timeline?
Yes.
Not to my knowledge. I don't know when Sergeant Bricker produced his specifically.
And isn't it fair to say that as of the moment that Tyler Robinson voluntarily surrendered to authorities in Washington County, as of that moment, you all did not know who the shooter was? Is that right?
We had identified a person of interest, but we did not specifically know who the shooter was at that time.
Okay. And you became aware that Mr. Robinson was leaders, did you know that?
I think I had heard that at some point. There was a connection, I didn't recall specifically what it was.
And Mr. Robinson, in fact, no police went to go arrest him. He drove himself, or he was driven with his parents to the Washington County Sheriff's Department, correct?
That's my understanding, yes.
And he voluntarily walked in.
That's also my understanding, yes.
And that was the first moment you ever knew his name connected with this case.
Yeah, aside from the image that we had, that was the first time that we had a name of an individual who had taken responsibility, yes.
And did you personally ever meet with Mr. Robinson?
I did not.
And as far as you know, Mr. Robinson did what he said he was going to do. He told the police he was coming peacefully, he was coming with his parents, and that's exactly what happened.
I don't know any of the specifics of how he was arranged to turn himself in terms of what you've described. I just know that it was being facilitated with the sheriff's office.
Okay. Court's indulgence for just a moment.
Well, she asked you whether Mr. Robinson voluntarily went to the sheriff's office down in southern Utah. Is that right?
Yes.
Okay. And that was the Washington County Sheriff's Office.
Yes.
Okay. You understood that he turned him. Well, he showed up there voluntarily. Is that right?
Correct.
What was your understanding as to why he was showing up there voluntarily?
He had informed, I believe, his immediate family that he had been involved in the shooting and that he wanted to turn himself in.
Okay. Nothing further. In the video that we've already talked about, the video where Mr. Robinson stands up and runs across the top of the LOC building, do you notice whether at that point, after he stood up until you see him last, at least in that part of the video, do you notice whether he's walking or running with a limp?
He is not. From the time he left after going over the railing, when we see him on the video move out to the position.
Correct.
And then leave the position, there is no longer a visible limp or gait.
Thank you.
Ms. Nestor.
No follow-up, Your Honor.
All right. May Agent Hull be excused?
Yes, Your Honor.
All right.
Use the difference, or the Christian and political view regarding marriage and families and gender identity. And that information is relevant to the motive that we are alleging in this case. And it's also relevant to the victim targeting enhancement, which is in part a motive type enhancement. And the evidence will be introduced through, or we will offer evidence through other witnesses that talks about some of the defendant's statements that indicate his gender persuasion, and that he falls into some of these political and gender views that Charlie Kirk argued against. That's the relevance of this statement, is it shows Charlie Kirk publicly, in front of large gatherings of people, debated and presented his views, his political views, which were tied to his religious views about gender identity, LGBTQ rights type issues. And the relevance to that is the defendant's motive is that he was on the other side of those views. And you'll see evidence that talks about that through other witnesses.
Any question that the court asks is a question that counsel should take seriously. The legislature separates in the statute religion and political expression. The state selected the victim targeting enhancement based on political expression only. Now the state wants to I didn't bring Matthew in. The state is bringing Matthew in through Mr. Engelhardt. I didn't bring the Bible to this courtroom, the state brought it. And that concerns me greatly because the state is turning this into a question of whether Mr. Robinson's views, identity, life are anti-Christian. And that's a huge problem. And the state has created that problem. And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride just did, is he turned this case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views. I'm going to just stop right here because I think the court knows what the problem is.
Thank you. All right, anything further before the court makes it? All right, Mr. McBride, turning to the state.
Yes, Your Honor. Just by way of preview, we are going to call Jen Faumuina, Sergeant with the SBI, but how we're going to proceed is we're going to call her for a very limited purpose. We're going to pause her testimony. Defense is not going to cross at that time, and we're going to call an FBI DNA analyst out of order. It's a defense witness, but that's to accommodate that witness's schedule. Okay. State calls Sergeant Jen Faumuina.
Like to come forward? I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors at the top of that page, if you will.
Yes. Male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 7 sub 1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver. Is that right?
Yes.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8 sub 1. Item 8 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Okay, thank you. A couple of foundational questions before we finish for now. First off, do you know who Twiggs is?
Yes.
Who is Twiggs?
Twiggs is Lance Twiggs. He was a roommate of Mr. Tyler Robinson.
And do you know if Lance Twiggs' DNA was obtained?
I'd like to reserve the right to cross-examine after the witness completes her testimony after the following.
Oh, would you mind grabbing the microphone? I just want to make sure what you say is on the record.
With the court's permission, I'd like to reserve the right to cross-examine on the area she testified about until she's completed her testimony.
Okay, I see what you're saying. Any input, Mr. McBride?
Your Honor, that's what we expected to happen. We discussed this beforehand. We stipulate.
All right, that's fine. And so should I have the sergeant step down, or?
Yes.
Okay. Sergeant, if you'd like to step down, you're still under oath, and so please don't discuss your testimony with anyone. And is she being asked to exit the courtroom, or what's the request of the parties?
Yes, to exit the courtroom at this time.
All right, Agent, if you wouldn't mind exiting the courtroom, and then we'll come get you when we're ready for you. All right? Thank you. All right, Mr. Burt, turning to you.
Your Honor, out of order, the defense would be calling Amanda Baker.
All right, Ms. Baker.
Page 22 of your case file notes.
Okay.
And if I could direct your attention to the bottom of that page, there is a communication log entry dated September 13th. Do you see what I'm referring to?
Yes, I do.
And would you read to the court what your entry is for that date?
Yes. This is my communication communication entry on September 13th, 2025. All. Spoke with FBI Special Agent Folger and Utah SBI SA Dave Hull. Gave technically reviewed results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate reflection of what you told the agents at that time?
Yes, it is.
And you told them that, quote, Robinson was included as a possible contributor to the DNA from the towel and the screwdriver, correct?
Yes.
Was the language that you used in conformity with requirements that you have for reporting out test results?
Yes.
All right. I'd now like to direct your attention. Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct. No, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty.
That is correct. It was not.
Okay. And then the next one, not that one, one more down. Not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says, an examiner may not state or imply that forensic autosomal DNA examinations have a zero error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a zero error rate, correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm
You can
sorry.
take that down.
Can you clarify your question?
Yeah. When it refers to don't state that there is a zero error rate, what in general are the sources of error in DNA, in the kind of DNA testing that you do?
Human error could be an error.
Anything else?
Not that I can think of off the top of my head. One of the big things is potential human error. I guess you could also associate the DNA testing itself and how items are collected or how those items are tested.
Now, to your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you display 8 for us, please, to the witness? Let me know when it's up. No, not on the big screen.
Okay, so not to go onto this main big screen.
Correct, this is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
Okay. And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
All right. Does this same policy state at page 4, fourth down, one more. No, next one. An examiner, does the policy state, an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample?
That is correct, yes. It does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted and are stated in your report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Okay. Thank you. You can take that down. Are you also familiar with a concept called formal activity level?
Yes, I am.
Tell the court what that is.
Formal activity level is determining an activity that causes DNA to be left behind on an object.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
And consistent with that policy, you cannot tell, if you interpret a piece of DNA as being present on an item, you can't tell when that DNA was deposited, correct?
I can't give an exact time, but there are some that I can increase my number of contributors to 3, which I did in this case.
Okay, and when did you reach that conclusion, time-wise?
If I recall, it was somewhere around September 12th.
And when did you change your conclusion?
That I would have to refer.
Sure.
I changed my conclusion on September 13th of 2025.
And explain to the court why you changed your conclusion?
I was submitted an elimination sample from Mr. Twiggs, and an elimination sample is a sample in which it's from a known individual, and then there's an expectation that the individual's DNA might be present. In receiving that sample and talking to the investigators, it was decided that Mr. Twiggs should be used as an elimination. When I compared him to this sample, all of the DNA, unlike that major contributor, matched to Mr. Twiggs. So because of that, I determined that there's actually only 2 individuals because those small peaks, there was nothing left for a third individual to be compared to.
You use a phrase, Twiggs was someone whose DNA you would expect in those 2 samples.
So from what I recall, in speaking with the investigators, Mr. Twiggs was a roommate of Mr. Robinson, and it was thought that those items came from potentially Mr. Robinson's home. And I don't recall exactly if it was a situation where a particular towel was known to have been in that house. I don't remember that exactly. But in talking to the investigators, based on their investigation, it was important to assume potentially Mr. Twiggs was present.
Right, did any investigator ever tell you that the towel did not come from Mr. Robinson's home, but was found in a bush out at the university?
I was aware of that, yes.
So you knew that that towel was not found in a place where you would expect Mr. Twiggs's DNA to be present?
That is correct. It was found outside of a home, but again, based on speaking with the investigators, they had information to suspect that that towel came from Mr. Robinson's home, and I should utilize Mr. Twiggs as an elimination.
Right. And again, you didn't assume that you let's verify that if we could. Take that down, the highlight. And repost 38, page 45. I'm sorry. Page 39, that is in evidence. There we go. Second page. Is this the likelihood ratio from your Twiggs comparison?
Yes, it is.
Okay. Now, what was the likelihood ratio that you calculated based on this chart?
The likelihood ratio was 1.
1.
Yes.
So that doesn't rise to the level of even limited inclusion, correct?
Correct. It would fall under an uninformative.
Uninformative, and yet you concluded that despite this STR mix reading with a likelihood ratio of 1, that Mr. Twiggs was a contributor to both item 7 and item 8, correct?
I did. So actually, I didn't utilize this calculation to determine that Mr. Twiggs was a possible contributor or that I could use him as an assumed contributor. I visually looked at the DNA sample, and the DNA, unlike that major contributor, he also had those peaks. So that was one proposition or one hypothesis that I determined that he was an assumed contributor. There are multiple different ways. We don't have a threshold. I don't have to see 2, 4, 8 peaks to determine I think an individual is present. Given that the field submitted him as an elimination, I assumed he was a contributor. When I compared him to that data, I did see his DNA present. So when I calculated the statistic for Mr. Robinson, I used Mr. Twiggs as an elimination.
Let me see if I understand that. The STR mix that you relied upon to include Mr. you relied on the STR mix to include Mr. Robinson as a possible contributor, correct?
Correct, yes.
But when you ran Mr. Twiggs's sample through STR mix, the result you got was that he was not a contributor, correct? Or that it was of not even of limited value in including him.
Based on the Star Mix run, it was uninformative, but I did use my own knowledge and training to determine that I was going to utilize him as an assumed contributor.
Okay. Your own knowledge and training. Is there some standard?
To consume?
Yeah,
Yes.
okay. Now, remember I referred to that NRC report?
Yes.
1996. Did they say there a wrongfully accused person's best insurance against a possibility of being falsely incriminated is the opportunity to have the testing repeated? Such an opportunity should be provided whenever possible.
Yes, that does say that.
And does your laboratory have a policy, standard 7.4, which says, where possible, the laboratory shall retain or return a portion of the evidence, sample, or extract?
That is correct. And we do actually return the remaining extract, the liquid from our DNA testing. So we did consume the swab. However, there was a small amount of liquid that was left and returned.
On some of the items, right?
I believe on all of the items.
Well, we'll get to that in a minute. And that policy that I read is from your lab policy, right? The
Yes.
FBI's lab policy.
Yes, it is.
And then is there also a similar policy from the quality assurance standards, the FBI quality assurance standards, which says the laboratory must have a policy on sample consumption. The policy is expected to provide instruction for if and when the laboratory may or may not consume a sample and any documentation that the laboratory requires.
That is correct, yes.
Okay. Now, your report indicates that certain samples were destroyed, consumed, correct?
That is correct, yes.
And which samples were consumed?
Items 1 through 6, which were swabs from possible smudge, swabs of hand swipe, swabs from possible sweat drop, swabs from possible smudge, swabs of possible smudge, and swabs from possible sweat drop. In addition to items 54 and 55, which were swabs of swiped finger areas and swabs of stairwell railing.
Okay, so when you wrote in your report that those items were consumed, which of those items, and by that you mean the actual swab was consumed?
Correct. So a swab is just like a Q-tip. So the cotton portion of that swab was cut off the wooden stick, placed into a tube, subjected to DNA testing. So we consider that consuming. But again, there is liquid at the end of the process that is returned to the field.
And the normal procedure in terms of sample preservation would be something called sample splitting, right? You split the swab and you use half, you save half so that your testing results can be replicated and retested.
So yes, however, again, I don't know how an item is swabbed. So even if I were to cut that swab in half, it could be that I'm testing the half that doesn't have any DNA and the other half may have some DNA, or the swab may have a little bit of DNA on one side and a lot on the other side. So for the best possible chance of getting a DNA profile, it is our practice to consume the entire swab.
So for the first 6 items, those were swabs that were taken from the northeast corner of the Losi building, correct?
Correct, yes.
And you used all of the swabs, and you concluded that there was no DNA present on any of those items, correct?
That is correct.
So you couldn't do any comparative testing.
Correct. There was nothing for me to compare to.
Okay, and what did you have left after you did that in terms of the volume of extract? What was left?
So it was approximately 3 microliters, so a very small portion.
Very small portion, and you actually used 10 microliters to do your testing of those samples, right?
That is correct, yes.
So if you didn't getting your results with 10, what you left over would not be sufficient to get any sort of independent testing done, correct?
It could be tested, however, my expectation, if I took 10 microliters and did not get any DNA, the remaining 3 would also still not give me any DNA.
Okay. And for item 55, that was 2 swabs of a stairwell, from a stairwell railing where the suspect touched the railing, right?
As far as I know, they were swabs from a stairwell.
And correct me if I'm wrong, but I understand from your lab notes that you took those 2 swabs and combined them into one sample and then used the whole sample, right?
That is correct, yes.
Okay. Before you did that, did you inquire whether the 2 swabs came from 2 different areas? For instance, maybe the suspect touched it here, but the other sample was taken somewhere else?
I did not. They were both labeled as coming from the same stairwell, and they were packaged together. So our policies and procedures is that we can combine those 2 together.
And when you do that, you create a mixture, right?
I don't know that I would agree that combining the 2 would create a mixture. Given the item of evidence, a stairwell railing, I don't necessarily expect that one swab would have one person, the second swab would have a different second person, and combining the 2 of them creates a mixture. However, I don't know that for certain, but again, I don't know is DNA present, so our procedure is to combine and consume those swabs.
Okay. And in this case, when you did that, what you got was a complex mixture, right?
I did. I got DNA from more than 5 individuals, so I could not provide a conclusion.
All right. Now, and as you look at these 5 areas, you can't distinguish the evidence samples from Mr. Robinson based on the sequence differences, can you?
Correct. I only utilize length differences, STRs in this case. The FBI laboratory does not use sequencing for nuclear DNA testing, nor am I qualified in it.
All right. What is NGS?
NGS stands for Next Generation Sequencing.
And your laboratory is involved in validating next generation sequencing, correct?
We utilize next generation sequencing for mitochondrial DNA, which is a different subset of DNA testing, but not for nuclear DNA testing, which is what we're talking about today.
All right. But the people who market STR Mix also market a sequence platform, do they not?
I'm not aware if they do or do not.
Thank you. So item 7, sub 1, is the swabbing from the towel from the rifle. We have the number in a written form in the second paragraph beneath the heading, and then beneath that you have a table, correct?
That is correct, yes.
And the likelihood ratio gives the number, right? That's the likelihood ratio. And that's stated in sentence form in the paragraph preceding the table, correct?
Correct, yes.
The only language you can use to describe what that number means from the DOJ directive is very strong support for inclusion, correct?
Correct, yes.
And the sentence there that says the DNA results from item 7.1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The reader can assign whatever value they want to that, correct?
What do you mean?
Meaning adjective to describe what that means.
Sure, yes.
The adjective you can use is very strong support.
For inclusion, yes.
Okay, for inclusion. All right, if we go to 8.1, Kimberly, if you can scroll down just to make that a little bit easier to view. Same question there. The results are from 8.1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The adjective you're allowed to use is very strong support for inclusion again, correct?
Yes.
Well, you said that report was not authored by experts, but the head of that group was Eric Lander, who is one of the foremost experts in the area of forensic biology, is he not?
That name does not ring a bell. I don't know who that individual is.
You don't know who Eric Lander is?
No, I do not.
Okay. When did you go to school? What years?
2003 to 2007.
You said that STR mix was widely used and that it's been validated. The PCAST report said the problem is it's been validated by the people selling the product, right?
Developmental validation, yes. Internal validation, no. A laboratory that's going to utilize STAR mix has to validate within their own laboratory.
And the PCAST report said that we need validation data not by the people selling the product, but by independent scientists in order to make this reliable, right?
They do, and that's exactly what happened. There was 31 laboratories that came together in response to the PCAST report and gave their validation data on how they internally validated STAR mix.
And then after that information came forward, the PCAST committee reviewed it, and they said PCAST was unpersuaded by those studies. While likelihood ratios are a mathematically sound concept, their application requires making a set of assumptions about DNA profiles that require empirical testing. Errors in the assumptions can lead to errors in the results. To establish validity with a range of parameters, it is thus important to undertake empirical testing with a variety of samples in the relevant range. And they specifically address the studies you're referring to, did they not?
I believe they did, yes.
Yeah. And then lastly, you said that STR mix is widely used, but as I understand your testimony, you didn't use it and rely upon it for your conclusion about twigs, right? The software told you there was no support there for including them, and you ignored it and decided otherwise, correct?
I did not ignore it. Again, given the type of sample, it was an elimination sample. I compared that individual to the DNA profile that I developed and determined that I could conclude that I could utilize him as an elimination sample.
You said your laboratory was accredited, correct?
Yes.
But you're aware that in 2004, the Inspector General did a comprehensive audit of your laboratory and published a report called the FBI DNA Laboratory Report, a review of protocol and practice vulnerabilities, which found a number of errors in the way that your lab does testing, correct?
Objection. The 2004 study is hardly relevant to this proceeding 22 years later.
It's relevant because he's relying on accreditation to somehow say that these results are valid. This lab was accredited when this study was done.
I'll allow this single question. She may respond, so I'm overruling the objection, and then we'll continue to move forward.
You're aware of that study, right?
No, I'm not.
Okay, thank you. That's all I have.
All right. Anything further for this witness?
Yes, I think there's one follow-up that needs to be asked. You were asked that, or you testified that you never know the true answer with field work, correct?
Correct, yes.
And that's compared to ground truth studies where you do know the true answer and you can compare the conclusions that analysts draw with the true answer, the ground truth answer that is the basis of the study. Is that right?
Yes, and that is what our validation is.
Your validation actually studies is a ground truth test in essence.
Yes.
Okay, thank you.
Anything further for this witness?
Thank you.
May this witness be excused.
Yes.
Thank you, Ms. Baker. You may step down.
Thank you.
All right. Well, does either